The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15, Sunday afternoon at 1 o'clock. It again comes on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. Or you can give us a call. My number here in Des Moines is 515-276-3956. And John's number, area code 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that stands for Child Protection in Iowa. And it's those issues that we spend a lot of our time and effort simply to help families that are having difficulties with the Department of Human Services. As soon as they straighten up their act, I'm ready to shut down the office. And I wish that would come about. It seems to have been in practice here for a long time. I'm not sure that the huge mammoth operation is likely to fall apart in short order. It seems as though they're able, and they've been magnificently able, to gather sufficient support to build a gigantic empire, which takes about $2.3 billion of state and federal resources to run. And when you can involve a number of people who have lucrative jobs and who have lucrative contracts with the Department of Human Services, you build up a support group which makes sure that the entity that is behind all of this keeps functioning, even though the necessity of its product, protection of children, is not all that critical. You see, for an example, right now, it seems as though they seem to worry about sexual abuse. Sexual abuse, the prevention of sexual abuse through programs through the Iowa PCA, Prevent Child Abuse, just got a grant last year of $200,000 to put on programs such as the Happy Bear program to alert children that there are hazards out in the world. However, if you look at the actual problem of sexual abuse, you'll find that it consumes, that it amounts to only like 4.6% of all of the 37,000 cases that the Department of Human Services operates with. And some of those, I question whether or not even those cases would be valid if we actually had an opportunity to look at the elements of the accusations of sexual abuse. You see, this whole plan probably had a valid, purposeful setup when it was first invented to protect children. However, it's been used by divorcing spouses, and you know that our divorce rate is extremely high in Iowa. And it is a beautiful thing when you can, to a spouse that wants to make some headway, to use an entire agency to lob accusations. Now, the accusations, when they're lobbed, are such things as sexual abuse, um, and the person who makes the allegation does not have to identify themselves, does not have to sign any affidavits of truth or fact-finding, does not have to appear in court. Um, they can make life miserable for the other spouse or for a neighbor or for a landlord or anybody else that they have a pick at. And they have the entire agency behind them. So they're immune from prosecution. They're patted on the back for coming up with allegations that result in such things as founded reports. We're going to get a document up here for you to take a look at here in a moment. Um, and it's a technique I don't think that they had counted on using or counted on being a part of the system, and it's weighting the entire system down because people are finding that using the DHS as a weapon against someone they don't like is a very useful tool. We're going to be hearing from Don later on in the program. He's only been working on this, I think he said 23 years, in trying to get out of the department those things that he believes are essential in resolving a problem that they brought to him, not a problem that he brought to the department. There are people who are only too happy to get anything they can out of the DHS. For an example, some people think foster care is just a high grade of babysitting. You know, if you want to be gone for 3 weeks, you just put your children in foster care. No, foster care is a far more powerful tool, and it's an antidote for a problem far beyond what some people consider. Just your inability, momentary inability to care for children is not a real good idea to invoke the power of the court and the resources of the state treasury to watch over your children in foster care. Had a mother that did that one time in North Carolina. She found it difficult after moving from Iowa to Carolina to find a job in Carolina, and she couldn't care for her teenage son properly. So she put her teenage son into foster care because I think she probably had this mentality that foster care is supposed to be a government babysitting service. Well, it worked out for her because she found her way back to Iowa where she found a job, and at least part-time, and got an apartment and got things all set up to have her son back. And she says, called North Carolina and said, I'm ready for my boy to return. And they said, oh no, it doesn't work like that. You'll have to have a home study. Now, I think they charge like $1,100 for a home study, and it takes all kinds of paperwork and problems and hearings and everything else. And she took a trip to North Carolina, and they told her that her boy wouldn't be going home with her because they didn't have to release him. Well, I looked at some of the federal laws, and I wrote to the senator, an old-time senator from North Carolina, and I said, I'm sorry that North Carolina has chosen to secede from the Union. It's obvious that they've done that because they're not following federal guidelines on one of their measures of 96-272 and returning, helping this mother to reunite with her son. Well, a short time later, the boy arrived in Iowa. after the senator had an opportunity to look into this. One of the things that we're facing today is a problem that appears time after time after time. Dr. Ralph Underwager, who is now deceased, came up with this imaginative quote. He said, "There is a danger in pursuing the unattainable goal of a risk-free society or risk-free lives." And that's what the Department of Human Services is all about. They want things risk-free. He says, here's the problem. We may adopt policies and procedures that have the unintended consequences of markedly reducing the liberties and freedoms of all citizens. Well, that is the case all too often. In fact, you probably saw in the news, because it hit the news pretty heavily in April, which just happens to be Child Abuse Month, a raid on a campus in Texas, in which they took 416 children from an LDS compound, Latter-day Saints compound. Well, without warrants, arrest without warrants, and arresting babes, toddlers, teenagers, 416 children, and simply took them away from their parents. If they can do that with children like this, then they can do that anytime, anywhere, under any pretense. Now, this is not to say that that we are certain that the children were not being abused. It's saying you don't move forward under any kind of public policy if you don't know that there is abuse. You first establish that there is a problem, then you send in law enforcement, not the other way around. Well, we're going to take a listen to a commentary on this. It's only a little over 4 minutes, and I'd like to have you give some attention to what happens when we raise the question, is it right to pull 416 children on the basis of an anonymous telephone call? Have we reached the point where we have completely abandoned our love of liberty, our pursuit of citizen rights, and have gone to something called risk-free lives? Are we prepared to exchange our liberties for risk-free lives? I think we need to think those things over again. Let's now take a listen, if we can get the buttons punched up correctly, and listen to what a commentator says about this situation in Texas. Should we jump in on the idea of maintaining risk-free lives for these 416 children, even if we don't know that there is a risk involved? Let's listen now to this commentary.
I'm Judge Andrew Napolitano, and the verdict is in on polygamous custody battle. Here's the question. By invading a Texas compound and confiscating children from their parents on the basis of an anonymous telephone call, have Texas state authorities engaged in a massive act of kidnapping? Here are the facts. On April 4th, authorities raided the Yearning for Zion Ranch in El Dorado, Texas, and left with them, taking 416 children. The raid was in response to a telephone call police received from a person claiming to be a 16-year-old girl whose 50-year-old spiritual husband had beat and raped her. The caller, supposedly named Sarah Jessup Barlow, has yet to be identified, and members of the polygamist religious sect, the Fundamentalist Church of Jesus Christ of Latter-day Saints, deny her existence. Over the weekend, a Colorado woman named Rosita Swinton was taken into police custody and charged with false reporting to authorities. While police say Swinton's arrest is not directly related to the Texas case, they admit that Swinton is a person of interest in the investigation due to evidence uncovered in a search of her home that suggests she might be the one who placed the raid-triggering telephone call. Authorities say they received another search warrant based on evidence of sexual abuse at the compound, including records that documented 13-year-old girls being married to adult men and teenage girls who were visibly pregnant. Last week, Texas District Court Judge Barbara Walther was faced with the daunting task of hearing arguments from nearly 400 attorneys, each representing one or more of the children. At issue was the fate of each of the 416 children already in police custody. Should the children remain permanently separated from their parents and put into foster homes? On Friday, Judge Walther issued her decision that, yes, there was sufficient evidence of abuse at the compound to warrant the children remaining in state protective custody for at least another 6 weeks. Starting this week, the government will collect DNA samples from every man, woman, and child who lived on the ranch in an effort to determine who belongs to whom and who is related to whom and how. A spokesperson for the Texas Child Protective Services said once the DNA testing is done, they will start searching for suitable foster homes for all of the children who are being held temporarily in a sports arena in nearby San Angelo, Texas, and cared for mostly by volunteers. So here's the question. Was Judge Walther's ruling just? Should these young, innocent children be permanently taken away from the only parents they've ever known and placed in foster homes based on this evidence? And under what circumstances can the government legally come into a home and take babies from their mothers? Here's my opinion. The right to have children and the right to raise children is a fundamental liberty. The Supreme Court has ruled that that liberty is akin to freedom of speech and freedom of thought. It can only be interfered with by the government if the government makes a particularized showing to a judge that the children were in danger of imminent harm. But mass sweeping arrests of children and interrogations of them without their parents present is not only unlawful, it's criminal. And any evidence the state gets from these interrogations of these children cannot be used against their parents. If you want to hear more of my opinions on this topic, check out my latest book, A Nation of Sheep, available in bookstores nationwide. You can also tune in to my nationally syndicated radio show, Brian and the Judge, every weekday from 9 a.m. to noon. And don't forget, you can always catch me right here on the Fox News channel throughout the day, every day. I'm Judge Andrew Napolitano, and that's my verdict.
Well, I thought you'd like to tune in on that commentary. The judge says, no way should they be entering into homes, taking away children, without probable cause. Have we left our senses? Have we left our constitutional rights behind for an unattainable goal of risk-free lives, risk-free society? Well, here in Iowa, of course, we probably should stand up for risk-free because we're somewhat the second level um, insurance capital of the world. So I think perhaps we, through the insurance business, seem to think that that we can offset our risk by buying insurance. So maybe I shouldn't be downplaying this whole idea of offsetting risk. But when we want to give up our rights to this unattainable goal, I think we should think twice about trading our liberty for a little security. And you will hear the term security every once in a while, like security guards at the courthouse. But how do we get those? We get those by giving up a little of our liberty. If we can trade our liberty for a little security, we deserve neither and should be denied both. That doesn't come from John Harvey. That comes from, I believe it's Thomas Jefferson. You can correct me on that when we switch over to our legal expert here. The judge of the judges, someone who has a high regard for the Constitution and the rule of law, who has a high regard for our need to resolve some of these legal issues in a court system which is far more reformed than what it is now. Let's talk to a court reformer. Let's talk to Terrance Walker.
Well, thanks a lot, John. You always give me a great introduction, and I'm hoping to live up to that one day. I can't recall the quote you were asking me. Who made the quote?
About the president.
No. This was, are we willing to give up a little liberty? Are we willing to give up, let's see, are we willing to trade our liberty for a little security? And if so, we should be denied both because you can't hope to give up enough to get the security that what some of these people are offering. And I'm not sure I want to give up a lot of liberty to have security in the courthouse.
Yeah. Well, I can't remember who said that. You know, I'm not a.
I think it's Thomas Jefferson, but I could be wrong.
I'm not really clear on who wrote that, but it sounds like one of the framers of the Constitution. But you know, I do agree with that. You know, because we do have to. I know it's a trade-off to balance liberty and security, but you know, when you go into something of that magnitude, and you do something based upon a confidential informant of that magnitude, only to not find that confidential informant on top of that, I mean, I think that clearly shows an abuse of the powers that be in that situation. And I do think that those individuals who, you know, even assuming there are one or two perpetrators of child abuse in that place, I do not think that it would warrant an action of that magnitude to go in and just take 400 children, over 400 children, and from reports that I've heard on CNN and one of the other news programs today and yesterday, they even took some adults right along with those children. One of the adults had to fight to get out of jail. I guess it was a lady who happened to be about 20, and the authorities didn't believe that she was 20, so they went ahead and jailed her or put her into the detention facility because they thought she was a kid. And there was another woman that's 22 who had an infant child, and she's in a facility, and they thought she was underage as well. But she chose to just stay in the facility with her child rather than leave her infant child, which I do think that is very commendable of her. I mean, you know, what mother would want to leave their child in an unknown facility or unknown place? But I wanted to get onto the subject of the judicial nominating process and views on what the candidates for president would, you know, basically do if they were in a position to nominate some future judges. Because I do think it's important that we have judges of the best caliber and that are going to be fair and impartial and live up to the standard that is and the motto that's on the United States Supreme Court building, which basically says equal justice for all. And you know, the frame and the original intent and founders of the Constitution to live up to their ideals of what a judge should do. And so I was scouring the internet, and I visited this issue about a month and a half ago when we were exploring some of the views of Senator Obama on what he would feel would be a good judicial nominee or a good judge, for that matter. And we weren't able to explore in detail at the time because I didn't have enough information on the other candidates. Now it's coming down to 2, maybe 3 presidential candidates. So I think what I'm going to do is just explore Senator McCain's views on what it takes to be a good judge and what is a good judicial nominee, because as the president, they've got to basically nominate the judge, and then the Senate has the authority to advise and consent. Now, it's been a lot of debate on what it means to advise and consent, and I think that, you know, part of the problem with the judicial nominating process basically is involving the confusion on what it means. Some senators and some people in the power believe that advise and consent means that they should just basically see if the judge can fog a mirror. Some go so far as to figure out where they stand in relation to all of their judicial philosophies, and if those judicial philosophies meet up with what they feel is right or wrong, then they go ahead and vote for them. But I think that the answer lies somewhere in between that distinction, you know, because I really don't think that, you know, we can necessarily say that, you know, a judge should fully agree with everything that we agree on. I mean, I think that's going a little bit too far. But at the same point, I mean, just because someone has a law degree and been a judge, that doesn't make them to be a candidate to be a good federal judge. Or if they have a law degree, that makes them, and they have no criminal record and a law degree, then that makes them a good suit to be a good judge either. So, with all that being said, I wanted to read an excerpt of by Catherine Jean Lopez, whose views on this matter. She basically states and cites some of John McCain's recent speech on the judicial nominating process and judges. And she goes on to say, and I quote, "Anyone who follows political and cultural news knows elections matter. McCain drove this point home last week in his speech about the judiciary. Speaking at Wake Forest, the Republican senator chided judges for blurring the lines between branches of the government, for disrupting the balance of our founders wisely drew up in their constitutional blueprint for our republic." And he's quoted as saying, "In the shorthand of constitutional discourse, these abuses by the courts fall under the heading of judicial activism." But he continued, "Real activists seek to make their case democratically, to win hearts, minds, and majorities to their cause. Such people throughout our history have shown great idealism and done a great good. By contrast, activists, lawyers, and judges follow a different method. They want to be spared the inconvenience of campaigns, elections, legislative votes, and all that. They don't seek to win debates on the merits of their argument. They seek to shut down debates by order of the court." And as a campaign boost, this is Catherine Lopez speaking again, McCain couldn't have have better enemies in his battle against judicial usurpation against American democracy. Howard Dean, chairman of the Democratic National Committee, has railed against McCain's, quote, radical right-wing judicial philosophy. This should be music to McCain's campaign's ears. In fact, they should play it as a campaign song when meeting with conservatives, many who still need to be convinced they have a stake in supporting his candidacy. As Dean hammers at McCain, he will be campaigning for a candidate with a radical left-wing judicial philosophy. McCain pointed out in his speech at Wake Forest that neither Senator Obama or Senator Clinton voted for Chief Justice John Roberts, a man who eminently qualified to serve on the Supreme Court. The presumptive nominee, Obama, neither understands the judicial's proper role nor the Senate's obligations when it comes to the president's Supreme Court nominees. During the Roberts confirmation hearings, the Illinois senator said the Supreme Court nominees should share one's deepest values, one's core concerns, one's broader perspectives on how the world works, and the depth and breadth of one's empathy. Obama wanted both liberal activists on the court and in the Senate to do the president's choosing for him. He doesn't understand the separation of powers. Although he's on the most radical end of the spectrum, Obama fits well in the Senate. If you've watched bits and pieces of judicial confirmation hearings over the past years, you've seen remarkable abuses by the senators, all in the name of politics. Clarence Thomas had to be publicly humiliated to get confirmed when a former Alabama General William Pryor was before the Senate Judiciary Committee in 2003 for a seat on the 11th Circuit Court of Appeals. He was asked how he could possibly serve on the court after he and his wife decided to reschedule their family's vacation to Disney World so it would not coincide with Gay Day there. Pryor's parenting decision spoke to his qualification for the court, and this is Catherine Lopez asking again. And again, that's Catherine Lopez's opinion. There's a number of other opinions on McCain's views on the judiciary. Another one comes from Law.com, Pedro Gutierrez and Kerry Levine. And they highlight McCain's role in the Gang of 14. And the Gang of 14 was a group of senators from both parties who helped broker a deal to confirm 3 appeals court nominees to avoid a vote some called the nuclear option, which would have banned filibusters on nominees. Observers say the accord cleared the way for the confirmation of Supreme Court nominees John Roberts Jr. and Samuel Alito Jr. And some conservatives criticized McCain's involvement in the Gang of 14 compromise and argued that the Senate should have nixed the filibuster. Others praised the deal, saying it maintained the rights of the minority party, something that would come in handy when Republicans no longer were in power. In a speech to the Conservative Political Action Conference in February, McCain tried to burnish his conservative credentials by pledging to appoint judges of the character and quality of Justices Roberts and Alito. Sarah Taylor, the former White House political director who departed last year, says judgeships will be a very motivating issue in the presidential election for conservatives, and she expects McCain to revisit it. One other thing I want to add, it seems that McCain also appears to want to part ways with his views on what makes a good judge, and in essence he basically separated himself as far as what he felt was a different view of judges. Now, he called, I think it was Obama, he called Obama's choice on the judges who would basically be judicial activists. Now, I have a quote from there, from McCain's speech. And he says, for both Senator Obama and Senator Clinton, it turned out that not even John Roberts was quite good enough for them. Senator Obama in particular likes to talk up his background as a lecturer on law and also as someone who can work across the aisle to get things done. But when John Roberts was nominated, it seemed to bring out more the lecturer in Senator Obama than it did the guy who can get things done. He went right along with the partisan crowd and was among the 22 senators to vote against this highly qualified nominee. And just where did John Roberts fall short by the senator's measures? Well, a justice of the court, as Senator Obama explained it, that one should share one's deepest value, one core concern. Now, these vague words attempt to justify judicial activism. Come to think of it, they sound like an activist judge wrote them. And whatever they mean exactly, somehow Senator Obama's standards proved too lawfully a standard for a nominee who was brilliant, fair-minded, and learned in the law, a nominee of clear rectitude who had proved more than the equal of any lawyer on the Judicial Committee, and who today is respected by all as the Chief Justice of the United States. Somehow Obama's standard, even Judge Roberts, didn't measure up, and neither did Justice Samuel Alito. Apparently nobody fits the bill quite, except for an elite group of activist judges, lawyers, and law professors who think they know wisdom when they see it, and they see it only in each other. I have my own standards of judicial ability, experience, philosophy, and temperament, and Chief Justice Roberts and Samuel Alito meet those standards in every respect. They would serve as a model for my nominees if that responsibility falls to me. And speaking to counter that assertion, Obama's spokesman Tommy Vietor countered that Barack Obama has always believed that our courts should stand up for social and economic justice, and what's truly elitist is to appoint judges who will protect the powerful and leave ordinary Americans to fend for themselves. And I did have an excerpt from one of Obama's excerpts. Well, I don't know, I've got a lot of excerpts here, but he basically seemed to also share that view, or highlight that view in his confirmation, or actually his confirmation hearing of Judge Alito a couple years back, where Obama said that, you know, Judge Alito didn't stand for the common man or the small company, but the big corporation and the rich and powerful. So, I mean, I would tend to, I don't know, I think I would tend to see where he has some basis in making that decision, especially since the Supreme Court on their building says equal justice for all, and this country was set up to basically counter against the big powers that be, namely, especially because of the way that England treated the early colonists. And then lastly, as it pertains to some of the opinions of Alito and Roberts, justices of the United States Supreme Court, I have an excerpt from some of the highlights of their opinions. This also comes from law.com, I believe. Let's see. We've got a couple of the decisions that they've made here recently. It says that they, in a couple of cases, Bowles versus Russell, Gonzalez versus Carhart, and FEC versus Wisconsin Right to Life, National Association of Home Builders, and versus Defenders of Wildlife, Hine versus Freedom from Religion. They basically says that these opinions, which were joined by Alito and Roberts, show that they have a respect for they don't have a respect for precedents, and they're nominating procedures, they did say that they had a respect for precedents. Following the doctrine known as stare decisis, Latin for meaning let it stand, the Supreme Court generally builds off of its prior rulings rather than overruling them. Yet in several cases, Alito and Roberts have treated this doctrine and the court's earlier rulings with a lack of respect, and they did so in those cases. In some of the other cases, they highlighted a lack for disrespect for the democratic processes. And one case in particular, Ledbetter versus Goodyear, Alito and Roberts ignored both the broad remedial mandate of Title VII of the Civil Rights Act of '64 and the intent of Congress in the Civil Rights of in 1991, in ruling that a victim of workplace discrimination could not sue her employer, even when intentional past discrimination continued to result in current disparities in her pay. So, there's a number of things that could be said, but, I think that, when it gets to the nuts and bolts of it, I do think that, there is some basis. In fact, I do agree with McCain that, there shouldn't be judicial activism or anything like that, and I do think that, he has played a major role in keeping the nomination process fair, and, in his participation in the Gang of 14. I do, however, not agree with his characterization of Obama's views on what makes a good judge. I think that, he tends to highlight some of the cornerstones of the Constitution and the basis for the foundation of the judiciary branch, which is to provide equal justice for all. And that's my 2 cents. I want to leave the balance of the show to you guys. I don't want to talk too much here.
Okay. Thank you so much for that analysis. Appreciate that. Appreciate your doing the research on that. Don, we need to switch very quickly to your problem. While it isn't your, I shouldn't say it's your problem, it's been a series of efforts that you've made to bring about some results. And sometimes you've been happy about it, sometimes not. Take on from there, Don.
Well, I'm not sure where to go from here, John. Were you going to run a tape?
Yes, you call for it and we'll run it.
Okay, this tape started, or I had a hearing a couple of weeks ago on my abuse report issue. And so we had a few minutes of a hearing, and we'll run that now, John.
Oh, well, we better push the right buttons, hadn't we? Okay, it'll take just a second here to get that click back in. I pushed an eject button, instead of.
I'll make a comment, John.
Okay, go ahead.
This goes back to 1985 when they made an abuse report against me, and I had a hearing, and it was found that I had not. There was no abuse in my home, and yet DHS refuses to unfound and expunge the report. And years go by, and they've destroyed a family, and the only thing left is my daughters are alive, and I appreciate that. And
okay, here comes the movie if you'd like to see that. Okay, we'll see what we can drum up here. Oh, come on.
This is a court session. 56893, and that is Donnie Burgmaier as the petitioner and Kevin Cannon and the Iowa Department of Human Services the respondent. These matters are usually held in chambers and are simply arguments and not usually on the record. Mr. Burgmaier has requested that this be recorded by the court reporter, and so we are going to make that record. There was a request for expanded media coverage, which the court granted.
Are you hearing that okay?
Handled appropriately at this time. As indicated, this is the time and date set for a hearing on petitioner's application for judicial review filed on September 4, 2007. This is an administrative appeal pursuant to Iowa Code Chapter 17A. In this proceeding, the district court acts in an appellate role and reviews the action of the administrative agency. Here, that is the Iowa Department of Human Services. And that is based upon the record that is made before the administrative agency. The issue that this court may consider at this time must be raised by the petitioner, Mr. Burgmaier, and have been in his application for judicial review. Those are, as specified in his petition, one, whether the DHS has a legal obligation to respond to the petition for declaratory ruling, that's under 17A.9, and number two, whether the DHS has an obligation to respond to his open records request. Since this is an appeal on the administrative record, no evidence is permitted by the court at this proceeding. Further, by order establishing a schedule for conduct of proceedings pursuant to Iowa
We're going with this, Don. You're asking the court?
This court,
Oh, you just want to run the tape? Okay.
Filed such an order and provided the parties with a briefing schedule. The parties then submitted their briefs and scheduled the hearing today, May 2nd, 2008 at 1:30. Present are Mr. Burgmaier, the petitioner, and Assistant Attorney General Diane Staley, and they are here to argue their respective positions. I have reviewed the briefs and will allow you to make your arguments at this time. Mr. Burgmaier, how we'll proceed is that you're the petitioner. I'll allow you to make your arguments. Then I'll allow Ms. Staley to have her arguments, and then you are given an opportunity for a brief rebuttal, and that'll close the record. Any questions on our procedure?
No.
Okay, you may proceed.
This action before us today reminds me of when I made the request for expungement of the abuse report and the resistance I got from DHS to even get a hearing, which then took me to the Supreme Court, which the court today does not have any information on, but the court made a ruling granting me that right. And we're again in court on a different issue, but the resistance is basically the same. The petitioner comes before this court with an alleged reputation of abusing his children. Petitioner has attempted to narrow the issue down in his brief as to how a declaratory ruling should be prepared according to... The petitioner has attempted to narrow the issue down in his brief as to how a declaratory ruling should be prepared according to Judge Arthur E. Gamble. Gamble also stated that the court is troubled by the department's refusal to review this matter in light of Ms. Wickman's recent admissions. Diane Staley, attorney for respondents, has continued well beyond what Gamble directed the litigants to do. Because of this, the petitioner cannot be properly prepared to argue against many of her false and twisted statements.
Mr. Burgmaier, can I interrupt?
Yes.
I was provided a statement to the court, apparently filed today. It appears you're reading that.
Correct.
Well, if you want, we can cut this short because I can just read it to myself. I don't need to listen to you read it to me.
I want to put it on the record, Your Honor.
Well, it's in the record. It's been filed. It'll be in the court file. That's the record that I need.
I understand, but I want to proceed. You know, that'll be...
Mr. Burgmaier, I have 500 or 600 cases. I don't need to sit here and listen to you read a statement that you filed with the court. I'm capable of reading it.
Okay, I'll summarize it.
I appreciate that very much.
Prior to this report, DHS has prepared a denial of critical care report. At the China hearing in November 1995, the court concluded there was no denial of critical care. It took over 2 years for the DHS to expunge that report. DHS also brought forth a sex abuse report at the China action. The court ruled that there was no sex abuse. Attorney Wickman stated to the ALJ there was no sex abuse. So the petitioner was forced to have a hearing on the abuse report that does not exist. It was 4 months after the ALJ hearing, in 1990, the petitioner ended up with a denial of critical care report that did not exist at the hearing. At that point in time, petitioner requested expungement of the denial of critical care report. That request was denied. In my statement that the court referred to that I filed, I went down through the response that the attorney provided, and I responded and made comments and corrections to what she had done. I concluded with Santosky versus Kramer, a United States Supreme Court ruling. The primary witnesses at the hearing will be the agency's own professional caseworkers from the state, and is empowered both to investigate the family situation and to testify against the parents. Indeed, because the child is already in agency custody, the state even has the power to shape the historical events that form the basis for termination. The reason why I put that in there is because DHS, all the way through, gets to create the history. History starts when DHS takes control. It is not based on the history of the family prior to that. The petitioner has, in good faith, attempted to challenge through straightforward inquiry the means by which the agency has performed and seeks to continue performance in the administrative appeal process.
Performs and seeks to continue.
Performance in the administrative appeal process. The opposing party is asking the court to depart from a careful review solely on the pertinent statutory mandates for a declaratory ruling. One must ask the opposing party to enunciate clearly what precedence has been set to justify a multitude of references in resistance to a declaratory ruling. The references are clearly outside the narrow scope of the statute, but which claim is made. The opposing party must articulate in a declaratory ruling the means by which one can be denied a clear and proper response to an inquiry process set forth by the Iowa General Assembly. I stand on all the paperwork I've filed. That's all I have to say at this point in time.
Thank you, Mr. Burgmaier. Ms. Staley?
Yes, Your Honor. I think it's apparent that what this case is about concerns a child abuse report that is dated from 1985. Mr. Burgmaier and the department have been in virtually constant litigation since the early 90s on this issue. I would like to address briefly, the court identified two issues that were part of the judicial review. I'm not sure, quite frankly, what the issues are, but with respect to the allegation that DHS has an obligation to respond to the petition for declaratory action, Judge Gamble has ruled that that was denied as a matter of law, so I think that issue has already been decided by Judge Gamble. And the other issue was whether the department had an obligation to respond to an open records request. The petitioner was seeking money damages for failing to respond to an open records request, allegedly. And I would note to the court that part of the motion to dismiss filed by the department was that you cannot join an action for money damages with a petition for judicial review. So I would urge the court to find, with respect to the open records issue, that there is no basis to have that heard as a part of this judicial review proceeding. At the time that Judge Gamble overruled the motion to dismiss that was filed by the state in this case, he seemed to have some concern that the petitioner was trying to raise an issue of newly discovered evidence, and that was the issue in the judicial review. the state has, in its brief, outlined all of the times that the issues raised by petitioner have been in a court proceeding, one way or the other. We've tried to give a flavor for the number of times that these issues have been litigated in the record that has been put together. The record is by no means the entire number of cases, first of all, that have been litigated, and certainly not the entire court file, but it does reflect the number of times that the specific issue that Mr. Burgmaier is complaining about has been raised in front of a court or in front of the agency and ruled on. The particular complaint that seems to permeate this case is that Assistant Attorney General Mary Withman made a misstatement to the court that has somehow prejudiced the petitioner through all these years, and that statement concerned whether Mr. Burgmaier's ex-wife had requested expungement of the child abuse report in question. First of all, that issue has been argued since at least 1992 by Mr. Burgmaier. It has been ruled on by Judge Hutchison, by Judge Novak, I think by Judge one other judge. It's gone up on appeal a couple of times, so it is not a new issue. We have cited in our brief the standard for newly discovered evidence. First of all, it must be newly discovered, it must be material, and it will result in a change to the outcome of the case. None of those criteria are met. This is not new information. Mr. Burgmaier has been aware of it since at least 1992. It's not material. It has nothing to do with the merits of the case. The courts that have considered the issue have all considered it and not made any change to the merits of their ruling. And it certainly would not have changed the outcome of the case. In particular, I'd like to point out that while Mr. Burgmaier alleges that a mistake was made that caused the administrative law judge back in 1990 to change his mind, actually what happened was the administrative law judge ruled in Mr. Burgmaier's favor. So I don't think that there's any way you can say that it would have affected the merits of the dispute. I believe that our brief and the record that's been compiled in this case sets forth the state's position, and I would rely upon that.
Thank you. Mr. Burgmaier has indicated I will give you an opportunity for a rebuttal argument. You may proceed.
The attorney was stating to the court the names of judges that's been on this case. She couldn't remember Judge Bergeson, I assume.